There's one habit I wish more people picked up on, especially if it involves money, work, or favors. And no, does not involve hiring a lawyer. It's something simpler, but it's something really powerful. If it's not in writing, it never happened. So when things are still good, always try and document everything in writing, especially if you have more to lose from a particular transaction and if you feel like it's better if it's reduced in writing. As a rule of thumb, it's better that all key commercial transactions or all key transactions which involve considerable financial obligations, that the same be reduced into a contract. But there are certain instances where maybe circumstances or the parties might be a bit slippery, and shoving a contract down their throat might not be the best idea, might not be the best way to approach the situation. So question is, how do you tie down such a slippery person? How do you create legally binding obligations between a party who is very slippery, does not want anything in writing, does not want anything to do with the contract, but you are really keen on still relating with this particular person, either through work or other commercial transaction or relationship that you want to undertake between the two of you. So how do you create this legally binding obligation in an awkward way? I'm going to give you 2 scenarios and a script for each on how to approach each situation. The first scenario is a boss who is allergic to paperwork or who hates paperwork. You're at work, the boss tells you, hey, please take on these more responsibilities. I'm going to raise your salary by X amount, starting from, let's say, end of next month. It sounds nice, it sounds flowery, but at the back of your mind, you know this is not in writing. He could deny he ever told me that. But you're also cautious, you're an employee. You don't want to make things unnecessarily awkward. So how do you approach it? Here's what I'd recommend. Try and send an email message or a text message to your boss along these lines. The same day, hi, just following up on our conversation earlier today. You mentioned that I'm going to be taking on A, B, C, D roles, and my salary is going to increase by Kenya shillings this much, starting from the month of May. Please confirm if I understood everything correctly, or if there's anything, or if there's any detail that I've missed from our earlier conversation, or if there's anything that I did not understand well from our earlier conversation. Here's the catch. If they fail to respond, that silence is legally useful for you. If they respond even with a simple yes, or something like thanks, even better. Because in a court of law, that email is going to be used as a contemporaneous record, just to show that indeed around this time this email message was sent, and you also have proof that you took on more responsibilities. So if down the road they change the narrative and say, I never promised this, you pull out the email message. I wrote to you this email message seeking clarity on A, B, C, and D. You never got back, you never responded denying it. Or in fact, you can even say you responded and said yes. So what has changed? So such an email message can really help you in such an instance. It shows you as a professional and not as a confrontational person. Because it's an innocent email message from an employee to an employer. Nothing confrontational, just purely professional, just seeking clarity on 1 or 2 things. Your boss might not read much into it and they might just respond casually, yes. And by that response, you've nailed them. It will be very difficult for them now to change guns and try and change the narrative. That is scenario 1. Scenario 2, you want to engage this service provider or a fundi to come and undertake some repairs for you. You want a seat to be made or a couch to be made for you for your house. So you hire this carpenter to come and do the works for you. The carpenter tells you, this is very simple work, this is very quick. There's really no need for a contract here. You know the carpenter is good, so you don't want to be confrontational, or you just want to keep things easy. Same example as the other one. Send this exact email message or text message, something along these lines. Hey, just confirming from our earlier discussion, we agreed that you're going to make for me this couch These are the details. These are the dimensions for the couch. You said you're going to make it within 2 weeks. Payment terms are that I'll make a deposit payment immediately and the balance to be paid upon full completion of the scope of work. Please confirm that this is in order, or if there's anything that sounds off, please let me know. So by sending that email or text message, you've locked in the price or the value for the work to be delivered. You've locked in the dimensions or the details of how the couch is supposed to look like. You've locked in the timelines. It will be very difficult for, let's say, that carpenter to change the narrative down the road and for them to inflate the price or to do some shoddy work or to deliver something totally different, because you have that in written form and you can always pull it out as evidence of what was agreed between the parties if they try and change the narrative. I wrote to you this email message, I wrote to you this text message, but you did not object to it. In fact, you actually agreed to it. You sent a response to the text or to the email message in the affirmative. So there's no way now you can change tact or try and change the narrative right now. So bottom line, oral agreements are enforceable in this country. But remember, courts are going to give more weight to what you can actually prove. So based on learning points from those two examples I've given you, always try and reduce what has been orally agreed in writing, even if it is casually done by a simple text message or a simple email message. That text or email is going to save you everything. Could be the difference between you getting your way in court and pleading your case successfully, or you completely losing out on that case and losing out on your hard-earned money just because you failed to send a simple text message or a simple email message just to try and protect your interests. So yes, oral agreements are valid, but always try and reduce them in writing in a way, even if it is casually done. It will save you everything.